probably may know that UVA was founded by Thomas Jefferson to provide an education free from religious input, and that Justice Scalia was a professor of mine first year in law school. So you talk about a scary proposition, Justice Scalia. But we're going to be running through this very quickly because of time constraints, and basically try to give you a little background about our case. Chesterfield County is a large suburban county just immediately south of Richmond. It reminds me very much of Winter Park. I don't know how these beauty contests are provided for, but as you can tell, it's a fairly well-off community. It has a budget of about $1 billion. Now let's go to the serious business of government. This is a typical Board of Supervisors meeting that you see in front of you. We have a 5-member Board of Supervisors. They're elected from single districts for 4-year terms. They appoint a chief executive officer. Now, we talked a little bit about the Lemon Test and some of the other historical cases involving the Establishment Clause, so I'm not going to spend a whole lot of time on that. Go ahead. But I did want you to notice one thing. Although the U.S. Constitution does not mention God, every state constitution refers to a God. And this is an amazing historical anomaly as far as I am concerned. The Virginia Constitution actually requires, as a constitutional matter, that people act with Christian forbearance, love, and charity towards each other. David, there's a lawsuit waiting for you when you get back.
If you can't be admitted to practice in Virginia, I'd be happy to file it.
There you go. I've sometimes asked my colleagues, have you ever advised your elected officials that they're not acting in board meetings with Christian forbearance? Nobody opens their mouth when I ask them that. But as to the development of the Establishment Clause, we've talked a little bit about, I think, Reynolds versus the U.S., which was the first, was the case outlawing polygamy in the Utah Territory. But the Everson case in 1947 was really the beginning of the modern Establishment Clause jurisprudence. And in that case, they referred to basically what was referred to as a basic principle of American government to separate church and state. Well, that basic principle of American government had only been mentioned one time before. And Everson was a 5-4 decision that allowed state funding of transportation to parochial schools. And Justice Black, who voted in the majority, was the chairman at the time, well, maybe not the chairman, but he voted in the majority, and many people believe he did that to show his complete break from his membership in the Ku Klux Klan. Now, Lemon, of course, was the first attempt really to craft a neutral principle to test, when do we determine whether a law or regulation violates the Establishment Clause? Well, that neutral principle really hasn't worked out quite that well, particularly since incidental effects that advance or prohibit religion or modest entanglements of church and state are allowed by the Constitution. And so this is the familiar Lemon Test that we've seen, but what does it really mean? Well, what it really means is that our law tolerates a large amount of ad hoc and unpredictable kind of results coming from Lemon. So just to give you a quick visual view of that, rather than a clear separation, what we really get is a blurred, indistinct, and variable relationship between government and the Establishment Clause. Now, these are visual examples of application of the Establishment Clause to the Ten Commandments issues. This is a display of the Ten Commandments in Alabama courthouse that was declared to be unconstitutional. Again, at Pennsylvania courthouse, this is the display of the Ten Commandments outside. That was declared to be constitutional. This is the McCreary case, which David will talk about. That was declared to be unconstitutional. And there we have the Texas monument declared to be constitutional. Okay? All of it arising from the same provision of the Constitution. Go ahead. Now here we see the Freys at the Supreme Court building in their chambers. Guess what? They've somehow managed to find a way to keep their building constitutionally intact. That's inside the courtroom. Go ahead. And the next, that's the exterior pediment of the Supreme Court. Again, an example of the wildly unpredictable nature of it. All right, here's why we're here this morning, and that is talk about, can invocations or legislative prayer be limited to monotheistic traditions without violating the Establishment Clause? Some of those more cynical or worldly among us might have these kind of thoughts on occasion, but the reality is that legislative invocations are a widely held and long held and widespread tradition across the country at both the local, state, and national level. So let's turn to the real religion in the South, football. Okay? Several years ago, I found myself at a Clemson, Virginia football game, and I've spent every minute of my education at public institutions from kindergarten on. And I was shocked, really, to be subjected to a Methodist minister giving a long invocation to 80,000 captive fans. And in that invocation, he prayed for virtually everything, such as world peace and no injuries, except for Clemson victory, which I assumed they deemed to be superfluous, given who they were playing. And, of course, it did turn out to be superfluous, given the result. All right. So what happened after Lemon regarding legislative prayer? What we see is the Marsh case, a 1983 case which involved the Nebraska legislature, which had appointed a Presbyterian minister for 16 straight years. And basically he was paid using public funds, and he used prayers exclusively within the Judeo-Christian tradition. The issue was, did that violate the Establishment Clause? And the Supreme Court said, no, it did not. What they said was the method of selection of the person giving a prayer is not of constitutional moment as long as the prayer opportunity is not exploited to either proselytize or disparage another religion. Again, the process of selecting someone to give a prayer necessarily includes excluding someone. And the court said that's not really constitutional moment. That's fine. That does not violate the Establishment Clause. It's not even a step toward violating the Establishment Clause. Now, Justice Brennan, in his dissent, was flat out apoplectic. He'd been the architect of much of the Establishment Clause, and he said, it's slipping away from me. What happened to the Establishment Clause? If judged through the unsentimental eye of our settled law, legislative prayer wouldn't make it. And what he said was basically any third-year law student could figure that out. So, in 1984, a year after Marsh, Chesterfield County adopted an invocation policy that mimicked the language of the Marsh decision. Basically, all prayers must be non-sectarian, no proselytizing or advancing. And you see in front of you there the invitation that's sent that said basically you may not mention specific images that are peculiar to a particular denomination. The clerk of the board sends out invitations each year. The volunteers are self-selected. The Board of Supervisors does not vet the prayer. They have nothing to do with the prayer that's given. And basically it's given exclusively for the benefit of the elected officials to solemnize the proceedings. There's no standing in the audience like we saw this morning, and people can come and go as they choose. So that is what has been the policy. Now what I want to do is show you quickly some two invocations that have been given in Chesterfield County to give you an idea of the nature of those invocations. I'm sorry for the flickering nature.
Let us pray. O God of all the ages, in your sight nations rise and fall and pass through times of peril. Now when our land is troubled and our men and women in the service are trying to keep the peace in troubled spots around the world, be near to judge and to save. Work through them that your justice may be established throughout this earth. Also, we ask that you grant our county leaders the gift of your wisdom. May they search your will and see it clearly. Empower them to see the needs of all those who reside in our county, especially the needs of children and the poor. And if any of us have turned from your way, reverse our ways and help us to repent. O Lord, give us your light and your truth. Let them guide us. For we pray in your name. Amen.
Amen. Thank you. Good evening. I begin in the name of God, the God of all the prophets, the most merciful and the most compassionate. All praise is due to him, the cherisher and sustainer of the worlds. And to him we ask for guidance.
All right, I'm not going to go through both of them, but both of those, as you can tell, are not proselytizing. They're not disparaging, and they both fit within the monotheistic Judeo-Christian tradition of prayers. Now, in the fall of 2002, Ms. Simpson made a request to give an invocation before the Board of Supervisors. And at the time, she said that she would reflect their respect for nature by speaking of natural phenomena such as the change in season, utterly benign statements. Ms. Simpson is a member of the Broom Riders Association in Chesterfield County, a group practicing a Wiccan form of witchcraft, and her personal spiritual practice has a witchcraft focus. The Wicca was basically founded by Gerald Gardner in the 40s in England, in which, at least in England, not here, all ceremonies were performed exclusively by females in the nude, basically honoring witchcraft, and the nature of the deity differs from the Jewish and Christian and Islamic traditions in that witches believe in an immanent or metaphorical deity, an energy or a life force, rather than a transcendent or supreme deity. Those are the differences with Wicca. Now, we know that the free exercise clause is much broader than the establishment clause, and so since there is no constitutional definition of a religion in our Constitution, free exercise basically is largely unlimited. You have a wide range of cults. Elian Gonzalez cult, for example, believes he's the Messiah. You have the Church of the American Knights of the Ku Klux Klan, and you have the World Church of the Creator, which was a church that proudly had as their catechism that the white race was their religion. So you can see here that Frank Zappa, a former philosopher of the Mothers of Invention, really there's not much difference between established religion and cults. So basically, at the time, Simpson was denied the right to give an invocation, nor was the invocation policy changed to open it up to non-monotheistic religions. These are the statements that politicians made in the public dialogue about the Wicca situation. I hope she's a good witch like Glinda. There's always Halloween. The next statement, it's a mockery. It's not any religion I would subscribe to. There are certain places we ought not to go, and this is one of them. You might think as a lawyer these statements might give me some problems. In fact, they really don't, because the policy had been in place for 20 years, and the elected officials really don't have much to say about the policy at all. Now, what happened at the trial level? We were sued. She's represented by the ACLU, and what the trial judge said was really the Fourth Circuit is distancing itself from the Lemon Test. Doesn't this sound like an endorsement of certain religions and not others by a governing body? Where is the governmental neutrality when you pick some and not others? Doesn't this look like a governmental preference for some people, not others? And doesn't this seem like there's some insiders and outsiders? These are all language that appear in the cases. And he found some factual differences as well. But basically, he said, I think this is unconstitutional. But he did say, if I open it up to everybody, how is the process going to tolerate the World Church of the Creator? It's going to get up there and make racist comments. So what he said was basically, we're going to have a happy message test, which means the government can limit the test, limit the invocation to a happy message. And of course, what he didn't realize is that many religious traditions are decidedly apocryphal or apocalyptic and not particularly happy messages either. So what you had at that point then was the trial decision. Go ahead. And these are, I guess, examples of the World Church of the Creator. They visited us earlier in another issue and used the library in Chesterfield County for one of their meetings. All right, go ahead. And again, this was an example of the ACLU said what the case was about, and it started off as about Cindy Simpson's ability to pray, but in reality, if you see there, it says even better to stop having prayers altogether. So fundamentally, it really was a political fight in the guise of a lawsuit. So, 1950s mentality, you see there the nuclear family, everybody's happy and smiling, everybody's white. In God we trust, kind of was adopted as a statutory requirement. So you have that 1950s mentality. And some people would fairly argue, well, look, Marsh was in 1983 was really just kind of the last parting shot of a 50s mentality. And so you had another 20 years from Marsh to Simpson in 2005, 55 years of societal change is the way I look at it. Does Marsh really have any relevance today, is the argument. And so back to the timeline, you see a Marsh down there is an island, then you see, go ahead. I won't run through them all, but you see all of the cases. You have creche cases using lemon. You have creationism, lemon. Another creche case, lemon. You have graduation prayer, lemon. Football prayer, lemon. Okay. And then you have Simpson and Marsh down there at the bottom, kind of islands unto themselves. The next case, of course, you have the various Ten Commandments case that David will talk about. Well, the Fourth Circuit basically resoundingly rejected the trial court. They said basically Chesterfield's openness to the ecumenism is consonant with our character, both as a nation of faith and as a country of free religious exercise and broad religious tolerance. It was a 3-0 decision from the panel. The ACLU asked for a rehearing involving all 13 judges, and they did not get a single vote to rehear the case from any of the justices. You may have seen that Judge J. Harvey Wilkinson is on President Bush's short list for appointment to the Supreme Court. So, but what the Fourth Circuit said, far from distancing itself from Lemon, the Fourth Circuit really characterized its jurisprudence as adherence. For example, they said a judge could not invoke a prayer in a courtroom because you don't have the same historical tradition. And in another case, they said the VMI, Virginia Military Institute, supper prayer was unconstitutional because there's no, again, history like you see in legislative prayer. So the Fourth Circuit really continues to embrace Lemon, but does find that Marsh is an island unto itself. Okay. What we do is we've quickly erased all of the Lemon-based law that David's going to talk about, and when you look at Marsh in a vacuum, the result that we got is not as wildly unexpected as some people might think. What we did get, the petition is scheduled to be heard by conference by the Supreme Court on October 3rd as to whether they'll take the case to the Supreme Court. What was interesting, an Micas brief, which is a friend of the court brief, was also filed by an American Indian, Native American association, the Buddhist and the Hindu. Interestingly and ironically, the same group of people that Justice Brennan in 1983 said would likely not be allowed to give invocations, 20-some years later, they're involved in the appeal. So, thank you for your time.
And rather than talk specifically about the McCreary County case that I had the honor of arguing at the Supreme Court, I want to talk about broader principles and discuss the McCreary County case within that context. It really is a pleasure to be here, particularly to talk about religious freedom, because it's a human right that I fervently believe in and the ACLU has consistently fought to defend. And because the ACLU is so often perceived and I think misperceived as being against religion, I think it's important to talk about why we believe as we do. Because I think that our views opposing government entanglement with religion is in fact the traditional American view, and that for more than 200 years that view has been good for both religion and government. So let's start by talking about the principles on which this country was founded. America was founded in the 18th century on two principles, two great principles, both quite radical for its time, both virtually unprecedented. One was the principle of democracy, the belief that people ought to have a say in the decisions that affect their lives, that they ought to be able to vote, and that the majority ought to govern most political decisions. We all understand that principle. From the first time we elect a class president or an eraser monitor, do they still have erasers in school? Eraser monitor, we understand that voting and majority rule is what governs our decisions. But there was another great idea in the founding of the country, and that was the idea of liberty. And liberty is not the same thing as democracy. It's the idea that even in a democracy, there are limits on majority rule, limits on majority power, that the majority doesn't get to decide everything, that there are certain individual rights and individual liberties that are protected from the tyranny of the majority. that just because there are more whites than blacks doesn't mean that whites get to decide whether blacks can vote or live or where they live, that just because men have more political power than women doesn't mean that women are relegated to second-class citizenship, that just because major religions have more adherents than do minor religions, that the majority can discriminate against the minority. And those principles, the principles of liberty, are enshrined basically in our Bill of Rights. Support for those principles, for both of them, for both individual liberty and majority rule, is what it means to support the American form of government. But the fundamental principle of liberty is not self-enforcing. It's fragile, it's always vulnerable to the excesses of the majority. It's also vulnerable to economic and political reality. It's government that defends its own power. Government doesn't fight for individual freedom from government. That's left to organizations like the ACLU and other opponents of government power. So with that contextual background, let's turn to religious freedom. As you know, the First Amendment contains two provisions dealing with religion. One, in effect, says that government can't do anything respecting an establishment of religion. The other says that government may not limit the free exercise of religion. Well, how do you go about letting people freely practice their religion without having government establish one? For the past half century, as Stephen has pointed out, what the courts have said, and I think they're basically right, is that you require government to remain neutral towards religion. You allow people to believe or not as they choose, to practice or not how and when they see fit. But you don't allow government to do anything that promotes, sponsors, or assists one religion over another or all religions over non-religion. Because when government does that, it essentially says that a particular religious belief or practice is better, and conversely that other religious beliefs or practices are wrong. And we know, and indeed the framers of our form of government were keenly aware, both from English history and their colonial experience, what happens when government says that religious beliefs are right, some religious beliefs are right, and some are wrong. In fact, former Republican Senator from New Hampshire, Warren Rudman, perhaps said it most succinctly. He had a three-word answer for those who wanted American governments to favor their religious beliefs: Belfast, Bosnia, Beirut. That's why we oppose government-sponsored prayer and creches and similar symbols on government property. Not because there's anything wrong with praying or celebrating the religious component of Christmas, but because the public schools and public property, the government schools and the government's property, our communal property, is the wrong place to do it. Well, how then has the Supreme Court measured governmental neutrality? Essentially, the court has applied the endorsement test or the Lemon test, they're pretty close, has applied the endorsement test, which looks to the purpose and the effect of governmental displays of religious symbols and text. The court has required government to have a valid secular purpose and for its displays to have an effect that, to the reasonably well-informed, reasonable observer, neither advances nor inhibits religion. That's what neutrality means, according to the court. Now, that test has been criticized by some as being too protective of separationist interests. Others think it's too subjective, too fact and context-driven to furnish predictive behavioral guidelines. Others on the other side think that the endorsement test doesn't sufficiently protect minority religions because the reasonable observer is, almost by definition, a member of the majority. But those who criticize the test itself have offered little to replace it, other than one test, the coercion test. The coercion test essentially says, and some members of the Supreme Court adhere to it, that government can do what it wants so long as it doesn't coerce particular belief or practice. The problem is that the coercion test would tolerate virtually any symbolic or explicit governmental endorsement that doesn't coerce religious belief or practice. That test would envision and tolerate an America where, in addition to Ten Commandments displays, governments would be free to post signs saying the Pope is a fraud, or billboards urging citizens to repent lest they fry in everlasting hell. That's what the endorsement test would tolerate. Others criticize the current law based on interpretive methodology. You've probably all heard about original intent and originalists. It's a big topic now with Judge Roberts' confirmation hearings. Their view, the originalist view, is that we should only look to the original intent of the framers of the Constitution in trying to figure out what the Constitution means. The problem, I think, with originalism is threefold. And this is not the time or the place to debate at length the propriety of originalism, but I want to make 3 points because it's really a limited approach to the Constitution. First, discerning the intent of the framers is no easy task. Deliberative bodies like the Constitutional Convention and the First Congress act through compromise, often displaying various or even mutually exclusive purposes and intents. We have a hard enough time figuring out what Congress meant when we look at the current Congress. We should be humble enough to recognize how difficult it is to figure out what Congress meant more than 200 years ago. And if there were any lingering doubt about the limits of trying to figure that out, it's worth remembering that that first Congress, the Congress that gave us the Bill of Rights, passionately and fundamentally disagreed about the meaning and purpose of the Constitution itself, the Constitution that had been passed 2 years earlier, and some of the framers were in that first Congress. They couldn't even agree what the Constitution meant. Second problem with originalism. Originalists can't ignore the fact that the framers themselves didn't intend for the Constitution to be interpreted according to originalism. In that first Congress, there were about a half dozen different interpretive means that people use trying to argue what the Constitution means. And it doesn't mean that any one of them is right or wrong, but the point is that if you're going to argue for original intent, the original intent was not to use original intent. The truest originalist thus has to acknowledge that originalism has no purer pedigree than any of the other methods that the framers in the first Congress used. Third, originalists often lack the courage of their convictions. They sometimes are unwilling to reach controversial and socially dislocating conclusions demanded by faithful adherence to original meaning. At other times, they're unwilling to reach results with which they disagree, even if original intent so required. And I'm going to give you 2 examples drawn actually from a recent book by University of Chicago law professor Cass Sunstein. It's a great book, and I can't remember the name of it offhand, but look up Cass Sunstein. It's well worth reading. The example to give, first one, the 14th Amendment's Equal Protection Clause. Can't deprive people of equal protection of the law. It's the only equal protection clause in our Constitution. It's also clear that it was intended to apply only to the states, not to the federal government. But it's hard to imagine that any originalist today would argue that the federal government could segregate its troops by race or could deny federal benefits based on gender. If they wanted to be true to originalism, though, that's the result they'd have to reach. It's equally clear that the Reconstructionist Congress, which conferred benefits through the Freedmen's Bureau, no relation, the Freedmen's Bureau to recently emancipated slaves, did not deem that benign race-based preference to violate the just enacted 14th Amendment. But this evidence of original intent is nowhere to be found in the opinions of those who condemn modern affirmative action programs in favor of their preferred policy of a colorblind constitution. The bottom line is that critics of the modern Establishment Clause have been unable to offer an alternative test or generally accepted method of interpretation that adequately protects an increasingly pluralistic America from governmental proselytizing. And that protection is necessary to further the values that are inherent in the religion clauses of the First Amendment. Despite all the criticism, the Supreme Court this year emphatically ratified existing law precisely because that law furthers the core values of religious freedom. Again, it does so by limiting government, not individuals, by limiting government in two ways. First, by precluding governmental interference with religious belief or worship, and second, by precluding governmental endorsement of or favoritism toward any particular religion or religious form of belief or worship. When government displays religious symbols, like the Ten Commandments or the Latin cross, with either the purpose or the effect of endorsing religion, it strays from the requirement of neutrality. How? How so? Why is it that showing the Ten Commandments or showing other religious text endorses religion? The short answer is that we ordinarily assume that those who display text endorse that text. Think of it in common life. When we see a Bush-Cheney yard sign, we don't think, they like the names Bush and Cheney. They probably named their kids that. We understand that they support a particular administration and its policies. So too with a peace button or a peace sign on a bumper sticker. We don't think that people like a particular geometric shape. We understand that they oppose a particular war, Vietnam in my day, Iraq today. The same is true of government. When government displays text, we assume that government endorses that text. And Professor Doug Laycock at the University of Texas has written widely on the subject, and he argues, and I think he's right, that government should be presumed to endorse the text that it displays unless there's something unique in the setting or the context that rebuts that presumption. And I'm just going to take a minute to explain that, and then one other thing, and then I will be done. So does it mean that government can never include a religious symbol or text in an otherwise secular display? Of course not. Government-owned art, government-owned art museums often will display, let's say governmental-owned medieval art museums will have lots of paintings with crucifixes. You couldn't have a medieval art museum without crucifixes. But we all understand that the museum is endorsing great art, not the artist's religious subject. When a government orchestra plays Bach's St. Matthew Passion or the Magnificat, we all understand that it's a celebration of great music, not the music's religious themes or text. So too, including the Ten Commandments in a comparative religion course or a neutral display comparing and contrasting ancient moral codes is perfectly fine. Indeed, barring the inclusion of religious text would be to disfavor religion. But governments seeking to post the Ten Commandments and to post other religious texts make no pretense of neutrality. To the contrary, they seek to display the Ten Commandments precisely because they endorse the content and the religious message. Well, in late June, the Supreme Court of the United States agreed that 2 Kentucky counties impermissibly entangled government with religion when they posted a series of Ten Commandments displays whose purpose was clearly religious. And I had the great privilege of arguing that case before the High Court. I want to leave you with a portion of Justice Sandra Day O'Connor's concurring opinion because I think it speaks far more eloquently than I can to the exact point that I tried to articulate here. Here's what Justice O'Connor said. Reasonable minds can disagree about how to apply the religion clauses in a particular case. But the goal of the clauses is clear: to carry out the founders' plan of preserving religious liberty to the fullest extent possible in a pluralistic society. By enforcing the clauses, we have kept religion a matter for the individual conscience, not for the prosecutor or bureaucrat. At a time when we see around the world the violent consequences of the assumption of a religious authority by government, Americans may count themselves fortunate. Our regard for constitutional boundaries has protected us from similar travails while allowing private religious exercise to flourish. Those who would renegotiate the boundaries between church and state must therefore answer a difficult question. Why would we trade a system that has served us so well for one that has served others so poorly?
The question I have for each of you is to, if you would, briefly survey the litigation landscape. And it seems like there's the blue state, red state disconnect on perspective. Secularist organizations and civil liberties organizations like the ACLU seem to feel that evangelicals are on a crusade to impose their religious views in the public sphere. Whereas if you listen to evangelical rhetoric, you would think that secularist organizations are on a crusade to run all religion out of the public sphere. And that's where the disconnect comes in. Would each of you address what is going on here? Where's the impetus? Where's the movement? Is it to drive religion out or to force religion in, or some of both? Just recently,
a town called Great Falls, South Carolina, was found to have violated the Establishment Clause when they tried to turn the town council into an exclusively Christian kind of experience. So we also see the Fourth Circuit basically not allowing supper prayer at VMI, a military school, and not allowing it in the judiciary context. So I'm not sure that there's any discernible movement. I think what you see really, and I don't think there's any blue state, red state, other than the Ninth Circuit, which is way off in left field. But all the other circuits, I think, are just honestly trying to apply the existing tests.
I think that's basically right. I think what happens is the law puts limits on what can be done. People sometimes understand those limits, they sometimes don't. I mean, the ACLU ends up fighting on both sides of these cases. We fight to keep government from endorsing religion. We also fight to keep government from excluding the private exercise of religion. So when schools don't let kids pray or read the Bible at lunch when they're free to read anything else, we sue schools over that. And I think what ends up happening is schools and governments sometimes don't understand the law, they overreact, and that's when you end up with cases. I think there is a discernible effort by some groups to get their particular political and religious view dominant. But that's true, I think, on both sides, both those who want their religion in and those who want all religion out.
You said one of the problems with originalism is that we don't know what the founders are thinking. But then you also said that the founders that intended the Constitution to be read intentionally. This seems somewhat paradoxical.
Maybe I wasn't clear. Let me try to explain it. One of the problems, I think, with originalism is that it's very difficult to talk about a single intent. Because you got 400 people together. 400 people vote, they pass a law. That doesn't mean that they have one intent. The people who ratify constitutional amendments are in 13 different colonies. They're a group of people, and they just get to vote yes or no. So it's very difficult to say there is a particular intent. My point about the original intent was simply saying not that we should look to original intent, because I think it's difficult to do, but if you were going to go and look at original intent, if you accepted the argument that originalism is right, it seems that the first Congress didn't use originalism as its way of interpreting the Constitution, because if you look at the debates, there are a half dozen different ways of interpreting the Constitution that they use. And no one said, whoa, that's wrong, that's not originalist. Some of them used originalism, some of them used, the technical terms, but textualism, structuralism, appeal to broader principles. They seem to use so many different ways of arguing what the Constitution means, that if in fact originalism was the only valid way, you would have thought the originalists would stand up and say, wait a minute, you can't argue that. That's not the way that you look to interpret the Constitution. Given that they didn't, it suggests that there's nothing pure and correct about originalism. I think that's what I was trying to say.
I recently read a case that the ACLU sued a Christian cemetery in California because the cemetery displayed a very large cross. The cemetery was funded by a Christian church. I believe the ACLU's argument was that it offended those who were not Christian who observed the cross. Would you care to comment on this?
Well, I don't know the case itself, and I suspect that's not what the case was or said. You read lots of things in lots of publications about what the ACLU did, and invariably they're not true. Invariably they're not true. The ACLU sues government. That's what the ACLU does. It sues government. There's a popular notion out there, too, that the ACLU sued to take down the crosses from military cemeteries. It's nonsense. It's just not true. If there were an ACLU position about that, the ACLU position, I can tell you as a matter of policy, would be, of course, private entities can have religious symbols on cemeteries, on graves, and anywhere else. That's where it belongs. Where it doesn't belong is on government.
There's so many legal nuances to what we've heard today. I'm wondering, is there any room in the legal interpretation for common sense factors to apply? For example, in the invocation we had earlier, or the prayer before a football game, or in those situations, the fact that you have people here that can quietly pray along with you, tune you out altogether, or curse you under their breath, and everyone exercises their freedoms and they go on about the business. Well, why can't something like that be resolved?
You know, the problem with common sense is your common sense might not be my common sense. But what you do see in the cases is a lot of 5-4 decisions, and David really didn't mention that. And what that's telling us, I think, is that there really is no unified or universally accepted common sense. When you have 5 on this side and 4 on this side, that's telling you something. And many of the cases that you see are like that. So, yes, there's still common sense. The University of Tennessee had a case in which they had a prayer at their graduation, and that was found to be acceptable because, you know, generally it's all adults, and so it doesn't have the coercive effect it might have in a 4th grade. So I do think common sense is hard to put a handle on, and you're seeing so many split decisions suggest that there's no universally accepted common sense.
I'd also argue, though, that where the court is now is pretty close to where common sense gets you, because people at both extremes are very unhappy. Those who want government endorsement of religion don't like that they can't have Ten Commandments displays and prayer in schools and prayer at high school football games. Separationists don't like the idea that you can have generic phrases like "in God we trust" and "God bless God save this honorable court," that you can have nativity scenes as part of a generally secular Christmas display. So the separationists don't think the court goes far enough. Those who want government to endorse religion don't think that the court has gone too far the other way. You know, that may suggest that the court's in about the right place.